Hi, my name is Matt Eichelberger, and I'm a criminal defense lawyer in Jackson, Mississippi. We service clients all over the state of Mississippi and Texas, primarily in criminal defense matters. There's another division of our firm that handles workers' compensation, and then I also handle some select civil rights cases that arise kind of out of the criminal justice system. So I've been doing this for over 20 years now, and I want to talk with you about the two phases of a felony prosecution in Mississippi. Now, I say two phases. These are some of the things that I've come up with. These are the terms that we use, and I think it's a pretty good way to kind of encapsulate the two different stages of a felony prosecution. So, I'm going to talk today primarily about the first stage, which is the pre indictment stage. The pre-indictment stage, the second one would naturally be the post-indictment phase. But first, let's talk about this pre-indictment stage. At this point, someone has usually been arrested already for a felony. Now, what is a felony in Mississippi? All it really means is it is a crime that is punishable by more than 1 year imprisonment in the state penitentiary. It can be 1 year to life, so long as the possible punishment is at least 1 year, then we consider that to be a felony. That can be anything from possession of a controlled substance that's like a Schedule II or something along those lines, all the way through a capital murder. All of those things are felonies under Mississippi law. And the key thing about a felony from a procedural standpoint is that there cannot be a conviction without either an indictment from the grand jury or what we call a bill of information, which is essentially an agreed to indictment. So that indictment is what divides a felony prosecution into these two different phases. Okay. It's the issuance of the indictment by the grand jury is what separates the two. All right. So somebody's already been arrested and they're facing a felony crime. A lot of times they're in custody when they are facing a felony. So if they are, then what that means is they're going to want bond and they're going to want it quickly, as fast as possible. So at the initial appearance for somebody who's been arrested for felony, that's what's supposed to happen within 48 hours. Mind you, it's really supposed to happen as soon as possible. That's what the Supreme Court has said time and time again. But under the rules, it's supposed to happen within 48 hours or less if possible. Now, if that initial appearance happens timely, then they are entitled to, in most cases, a bond. And not just any bond. Our rules say that it's a bond they can make, one that's high enough to make sure that they come back to court and they don't run off, but also low enough that they can post it and get out and go on with their lives so they can return to work or school, their family life, consult with their attorney, whatever it might be, and not have to sit prior to any trial. Because again, remember, they are presumed innocent at that stage. Now, uh, there are some exceptions when somebody's not entitled to bond, and we'll cover that in a second video. But for right now, understand that at that initial appearance, the judge will usually set a bond. Okay. The next thing that happens is they are returned to custody, and hopefully they can bond out after that initial appearance. And if so, then they can request, whether they're in custody or out, actually, they can request a preliminary hearing. Okay. Now, what is a preliminary hearing? A preliminary hearing is exactly that. It's preliminary and it's a hearing, right? It happens early and it's a hearing. So you actually have to go in front of a court. The state has the burden of proof. It's different than the burden of proof that you find at a trial, which is in the post indictment phase. It's different than that burden of proof. It is a lighter burden of proof. It's something called probable cause. It is an easier standard to reach than beyond a reasonable doubt. But it is a standard. There still has to be proof that a person probably did it. That's essentially what it is, right? Not that they maybe did it, or we think maybe they did it, or they could have done it. It means that they probably did it, that a crime was probably committed in the jurisdiction of this court, and that particular person is the one who probably did it. The state has to put on some evidence now, and usually that evidence is just testimony from a detective who's working the case. They don't have to put up the DNA. They don't have to do anything like that. This is not the trial. Sometimes it's as little as a law enforcement officer that's not even a detective, somebody who's been on the force for a few months, just reading the detective's report. And all it comes down to is the judge having an opportunity to look at whether or not there's probable cause in a case. And it's good for us as criminal defense lawyers because we can get in there and we can learn about the case. Sometimes we can convince the prosecutor, sometimes we can convince the judge there's not probable cause and get them to walk away from the case even at that stage. We've had that happen time and time again. I've done that even on murder cases. So it doesn't matter how difficult it appears at the start, that preliminary hearing is really, really important because it's an opportunity for us to learn and advocate for our clients. Um, so, under the rules, that preliminary hearing is supposed to happen within 14 days. And it's really the only opportunity we're going to have a law enforcement officer testify under oath, subject to cross examination about what's going on in a case. Okay. Otherwise, we're not entitled to it under our rules. You're not going to get it until after an indictment, right? So, in the post indictment phase. Right now, in this pre indictment phase, under our rules, we're not entitled to much discovery at all. We can't compel them to give us information during this first stage outside of that preliminary hearing. So that's why, we try to get in there as early as we can, have a prelim. And if the person's still in custody, sometimes we can get the bond lowered further. Um, and if they're out of custody, maybe there are some conditions we can have lifted at that preliminary hearing. So that kind of gives you an idea as to what happens at that preliminary hearing. Now, after the preliminary hearing, like I said, we've learned a lot usually through that preliminary hearing, and we can use that to continue the conversation with the prosecution. Now, in most instances, you will not have an assistant DA prosecuting the preliminary hearing. Most of the time, it is a county attorney or county prosecutor, rather, or the city prosecutor that is going to be carrying that thing forward at the prelim. All right, so what that means is it's not the prosecutor who is going to be handling the case before the grand jury where the indictment decision will be made, or at the post-indictment phase, like before the jury, right? The trial jury, or the petit jury as we call it. But again, that's talk for a different day. A lot of times the DA's office, they don't know exactly what's going on during that preliminary hearing, but we're there, right? So at the conclusion of the preliminary hearing, the judge will say something along the lines of, I find there to be probable cause and I bind this case over to await the action of the fill in the blank county grand jury. All right. So it goes from this preliminary hearing and now we have the information, and the case goes to the DA, and we can go to the DA along with what we know about it, right? Sometimes the DA is not even in possession of the file when we're talking to them. So we get to kind of set the stage early and put our spin on all this before they get the file. And we at least get to put our spin on it before they present that to the grand jury if we're in at this phase. And that can be very important. It happens all the time where law enforcement sees a case one way, and then we see those facts totally differently and can present our arguments to the DA in advance of the grand jury. And that will lead to things oftentimes like, an agreed upon resolution prior to an indictment. So we can talk about pretrial intervention where someone's never convicted of it. They basically stay out of trouble and then the case gets dismissed. Sometimes we can agree to resolve it on that bill of information that I mentioned earlier in this video, where you agree as to what the language of the indictment would look like. You do that in advance. You limit some of the exposure for the defendant and then are able to go in on a plea that's already agreed to that sometimes is very nice, a non-adjudication, sometimes something like that. Now, sometimes we can't agree, right? Sometimes the district attorney in our office, we can't get to the same place, and that's okay. They then take the case to the grand jury. Now, this is not the grand jury. The grand jury is not the body you see on Law and Order. Okay. It's not 12 men, 12 angry men. It's not 12 people in a jury box. It's not that, right? This is a secret proceeding, and it is there simply to determine whether or not a person probably did what the prosecution says they did. Okay. And if they do reach that conclusion, they issue the indictment. We do not get to be part of that. We're not part of the grand jury. We don't get to go in there and talk with them and present our side of the case. That's not what the grand jury is for. That's a secret proceeding, and only the DA's office is there to present evidence. They go in there with their witnesses, and it's the witnesses they want the grand jury to see, right? So they get to control the entire narrative. And sometimes they go in there looking to have the case no billed. What that means is the grand jury says, there's no reason to believe there's probable cause here, and that ends the case. Okay. So sometimes that's how a prosecutor can dismiss a case through a grand jury as well, okay, prior to an indictment. So that kind of walks you through most of what happens at a pre-indictment phase of a felony prosecution in Mississippi. Once the grand jury makes that decision, let's say the DA presents them with the evidence and they think, yes, hey, there is in fact reason to believe this happened, then they'll issue the true bill or the indictment, and that will then be served upon the defendant, who will then be presented with an arraignment date and all those other things that happen in the post-indictment phase. So I hope that gives you an idea as to what all this means, how it works. So if you have any questions, feel free to reach out to us. You know how to reach us. You've got all the things on the screen, and we look forward to helping you out. Thanks.